Hi friends, today we're going to discuss about Consumer Protection Act and Healthcare Services. I am Dr. Suresh Padmat, Professor of Psychiatry, Head of Telemedicine Center, Head of Forensic Psychiatry Unit at NIMHANS, Bangalore. Before I start my presentation, I would like to have a disclaimer. This presentation is for academic purpose only. If you want to have a legal opinion, please do contact an advocate. This presentation is not for legal opinion. Please do remember that. Conflict of interest? None. Consumer Protection Act of 2019 was passed on 9th of August 2019, approximately 1 year back, but it came into force on 28th July 2020. This presentation is focusing on Medical Profession and Consumer Protection Act 2019. What is in there for doctors? Do they come under the ambit of Consumer Protection Act? That is what we are going to answer in this presentation. Please do remember, this presentation has both argument and counter-argument. The argument that it is not there in the Consumer Protection Act because nowhere in the legislation it mentions about health, medicine, medical, healthcare services under the definition of services. If you look at the whole legislation, hardly in one place it is mentioned about medicine and health. Otherwise, nowhere it is mentioned. Hence, it's not there. At the same time, in the initial draft, when the bill was prepared, the healthcare was mentioned under the definition of services. But subsequently, the doctors lobbied with the government and requested the government to remove the healthcare from the definition of services. Of course, in the subsequent draft, the healthcare was removed from the definition of services. This is basically the government bid to pacify the medical fraternity which had expressed the apprehension over the law being used adversely against the profession. So most probably the government accepted it. Hence, these are the two strong arguments telling that it's not been defined, it's not there either mentioned or excluded. So the doctors feel that they are out of the Consumer Protection Act. These are the arguments and they're happy they're not under the Consumer Protection Act. But however, with the equal force, there is a counter-arguments. Counter-argument number one, service. Let us look at the definition of service. Service means service of any description which is made available to the potential users and includes but not limited. So please do remember this emphasis. Not limited to. The provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, housing, construction, entertainment, amusement, or the purveying of news or other information. So please do remember, though it has mentioned in this definition a lot of services, earlier healthcare was mentioned, but it is not there. But however, but not limited to gives a wider scope to be included, but does not include the rendering of any services free of charge or under a contract of personal services. Coming to this, please do remember the counter argument number two. It has excluded only two things: free services, that is, services rendered free of charge. They are excluded under the Consumer Act, or contract of personal services. That means if you have a cook at your house and you are paying salary for her, you cannot put a consumer case on her because you're the master and she is the servant. So there is no any consumer relationship here. She is not the service provider and consumer. It is a master-slave relationship. So in that, it is excluded. So coming to the counter-argument number three, the Apex Code. If you look at the World Consumer Protection Act of 1986, there also the healthcare profession was neither included or excluded. However, in 1995, the Supreme Court judgment in a case of IMA versus VP Shanta, it's a landmark judgment. In this, the Supreme Court was very, very clear, and it clearly articulated medical profession comes within the ambit of service, and it is in the definition of Consumer Protection Act. Since then, there are many judgments which have come in to the Supreme Court under the Consumer Protection Act. So it is there. whether the term exists under the law or not, that is under the legislation or not. A consumer who has been offered a service for a considerate has a right to approach the court if there is sufficient evidence that there is a breach of duty or medical negligence, and consumer has all the right to move to the commission. That's the way it goes. And also, the Apex Court clearly said that the relationship between the patient and the medical profession is as a contractual in nature. Remember that contractual word, because I'm going to repeat that again. Again, coming to the one more definition, counter argument number 4, deficiency. We talked about service, now we're going to talk about the deficiency. Deficiency means any fault, imperfection, shortcomings, or inadequacy in quality, nature, and manner of performance which is required to be maintained by or under any law for the time being in force. But however, now you keep this point very clear, has been undertaken to be performed by a person in pursuance of a contract. So that means the earlier Supreme Court judgment clearly said that doctor and the consumer is a contractual in nature. So now it's a contract and it is a part of the Consumer Protection Act 2019. At the same time, the deficiency is also been clearly said that any act of negligence, omission, or commission by which a person causes loss or injury to the consumer, it's fair well. At the same time, deliberately withholding relevant information by such person to the consumer. The doctor do not give information, like for informed consent. The deficiency clear comes into the picture here also. So it all fits into the Consumer Protection Act under the argument number 4. Argument number 5. Please look into the Consumer Protection Act Mediation Rules 2020. Under the rule number 4, it's very clearly has written that medical negligence related grievous injury or death should not be sent for mediation. Why it is so? Because medical negligence come under the ambit of Consumer Protection Act, my dear friends. The last argument, coming to the definition of consumer. See, the definition of consumer has become wide here in this legislation. It has two important things: buying any goods. Of course, the doctor may not provide goods, but the consumer is also who hires or avails any services, which includes both offline and online or online, transaction through electronic means or by teleshopping or direct selling or multi-level marketing. And this clearly clarifies the scope of CPA 2019. My dear friends, there is no doubt the counter argument is also very, very vehemently, clearly says that because of the Supreme Court judgment, and many judgments are there which clearly says the doctor and patient relationship is contractual in nature. And that is very clearly spelled out in Consumer Protection Act of 2019. My dear friends, to conclude, though the doctors are arguing that they do not come under the ambit of Consumer Protection Act because of the confusion that the health services have been removed from the definition of services, but however, the counter arguments are also equally impactful. This can be clearly by only two means. One, the legislation should be amended clearly telling that the healthcare services are excluded, or else the Apex Court should interpret the law by telling that healthcare is excluded. Till then, we are on board, my dear friends. What are the significant changes in the new Consumer Protection Act of 2019? The new goal is protection of the interests of the consumers. At the same time, to establish authorities for timely and effective administration and settlement of consumers' disputes. So, of course, the legislation keeps as the consumers are the favorite litigant in this legislation. At the same time, the legislation also enumerates 6 very important consumer rights. So, these rights which are enumerated under the legislations are to protection against hazardous goods and services, right to be informed about the goods and services, and also the protection against the unfair trade practices. At the same time, right to be assured about the competitive prices and to be heard about the consumer interest. At the same time, seek redressal if there are any kind of what we call it as grievances, and also right to awareness. Coming to the various authorities formed under the Consumer Protection of 2019 has a paradigm shift from the COPRA Act, that is the earlier 1986 Consumer Protection Act. If you see this, there are three different types of authorities have been formed. First one is Consumer Protection Council, next is Authority, and the third one is Consumer Dispute Redressal Commissions. Coming to the first, there are three different types of council to be established. One is at the Central Council, State Council, District Council. These are basically, these councils' main job is to protect and promote the rights of the consumers, and they are more of advisory in nature. However, there is a single authority is formed at the center. It is called as Central Consumer Protection Authority. It has been given a massive power to implement and also to protect the rights of the consumers. However, the monitoring and the regulating the whole process comes under the Consumer Dispute Redressal Commission. There are three types of commission has been formed under the CPA. First, District Commission. It is also called as District Consumer Dispute Redressal Commission, State Commission, Central Commission. After these three commissions, invariably they can appeal to the Supreme Court. This slide compares between the old legislation and the new legislation. The old legislation is Consumer Protection Act of 1986. The middle column is about the provisions. On comparing for the e-commerce, in the old legislation there was no discussion of e-commerce. But in the present legislation, they have clearly defined and the ambit of e-commerce. And also the intermediaries like the software companies are also brought under the ambit of this e-commerce. Mediation. The previous legislation, there was no mediation. Under the present legislation, there has been a significant amount of rules and regulations has been gone into the formation of this law. So it has been allowed and it has been streamlined. Now the consumers and the sellers or the service providers can discuss their problems and grievances under mediation. Coming to the product liability. As per the legislation, product liability is if somebody has sold the goods or the services, and if the consumer is not only harmed because of the goods, but also because of the harm, because of the product, that is called as product liability. Consumer can seek redressal not for the goods and services, but also for the harm. It may be physical harm and also the mental agony what he has sustained. So that product liability was not discussed under the previous provision, but at the current Consumer Protection Act, product liability is there. Coming to the pecuniary jurisdiction, this has a significant deviation from the previous legislation. The District Consumer Forum in the previous legislation was less than 20 lakhs. That means if the consumer has paid or claiming damages for less than 20 lakhs, he can approach the District Consumer Forum. If it is between 20 lakh to 1 crore, it is the State Consumer Forum. Anything above 1 crore, it was considered as National Consumer Forum. But in the present legislation, a consumer can approach the District Commission just for 1 crore rupees. The considerate, the word they used is considerate. The considerate is basically if the patient has paid any amount of fees, which should be less than 1 crore, then he can approach District Commission. If the patient has paid more than 1 crore rupees or within 10 crore as the pay for the doctor or the hospital, then he can approach the State Consumer Forum or State Consumer Commission. If anything which is the considerate is more than 10 crore, National Consumer Forum. So this pecuniary jurisdiction is definitely the cases at the District Consumer Forum will increase maybe up to 1 crore. At the same time, the another deviation is territorial jurisdiction. Earlier in the older legislation, the complaint can be registered only at the place of the seller's office. But in the present legislation, the consumer can give complaint either at his hometown or it is wherever he is working. It need not be at the seller place. That means if a doctor has given a service to a patient who is in a different city or in a different state, if he gives complaint in that state, the doctor has to travel. The best example I can give you is I am practicing at Bangalore. And if I see a patient from Calcutta, and if he has some grievance, he can give complaint in West Bengal, that is in Calcutta. So I have to travel or have to dispute that case in the jurisdiction of the where the patient stays or the consumer stays. So this is a paradigm shift. e-filing of the complaint, which was not there in the previous legislation. In the present legislation, it is there. Regulator. In the old legislation, there was no regulator or authority. In the current legislation, Central Consumer Protection Authority has been formed. And false misleading advertisement, that was not addressed in the previous legislation. The manufacturer, service providers, and the celebrities endorsing advertisement or false misleading advertisements will be penalized under the legislation. Unfair contract, which was not addressed in the previous legislation, now under the present legislation, the consumer can sue. Judiciary had a significant role to play in the previous legislation. Unfortunately, in the current Consumer Protection Act, the central government takes over that. This is definitely an issue to be apprehensive. And video conferencing of the case, which was not there in the previous, in the present case, in this present legislation, video conferencing is allowed for hearing of the cases. Coming to the offences and penalties. Section 88, not complying the order of the central authority, 6 months imprisonment with or without fine can be done, and the fine can go up to 20 lakhs. False misleading advertisements, first time 2 years imprisonment with or without fine up to 10 lakhs. Subsequent misleading advertisement, 5-year imprisonment with or without fine up to 50 lakhs. And another essentially important is selling, storing, or distributing, importing adulterant products or spurious goods. If there is no injury is caused, still there is a 6 months imprisonment with a fine up to 1 lakh. For a simple injury, 1 year up to 3 lakh fine can be given. Grievous injury, 7 years imprisonment and 5 lakhs, what we call it as the fine can be given. If there is a death, life imprisonment with fine up to 10 lakhs can be given under this offences and penalty. Coming to the critical appraisal, no doubt this legislation supports the consumer and considers consumer as the favorite litigant. Rights of the consumer has been comprehensively addressed in this legislation. Mediation is going to be the game changer in this legislation. Structural changes in the legislation is most welcoming. False misleading advertisements are punishable offense. Offences and penalties are very clearly defined, and up to life imprisonment has been given under the legislation. However, there are some drawbacks of this legislation. Appointment of the members of the commission is very worrying because the role of the judiciary has been curtailed. Central government is going to appoint this commission, so there will be some political gameplay in this legislation. It's the most serious drawback of this legislation. At the same time, entertaining complaint, registration at the consumer's place, that what we call it as territorial jurisdiction. The consumer can give a complaint wherever he feels right, either it is residence place or where he is working, not at the seller place. This is going to have a serious impact on the traders. This may impact even the telemedicine services, especially in the healthcare industry. E-complaint, giving complaint online, is going to increase enormously. Already Consumer Protection Act, under the Consumer Forum, they are already having a lot of pending cases. Having e-complaint will have flooding of cases. I don't know how they are going to answer this. This is going to be another game changer. Let me remind you, e-complaint is going to make a huge difference. Either it will come as a winner or this will be the self-defeating purpose of this legislation. Video conferencing of the case proceeding is an amazing one. The doctor need not go to the place where the case is occurring. He can appear through the video conferencing. But however, the pecuniary jurisdiction up to 1 crore in a district commission is slightly disturbing. This may lead to a lot of frivolous false complaints against the doctor. This will increase defensive practice. Ladies and gentlemen, coming to the end of my slide, please do remember, as a consumer, you are a winner. As a service provider, as a doctor, this legislation will add a lot of checks and balances to your practices. Please be aware of Consumer Protection Act. Don't think that you are not on board. At this point of time, you are on board in the Consumer Protection Act of 2019, unless a new legislation is formed with an amendment, or else the Supreme Court has to interpret the healthcare industry does not come under the Consumer Protection Act. Ladies and gentlemen, if you like this presentation, please do subscribe to my channel. Thank you very much for giving your time. Stay safe.